Good evening, everyone, and welcome to our continuous revision. So as I indicated yesterday, we are going to try and finish discussion of tort of negligence. So tonight, we will be discussing causation aspect of the tort of negligence, so causation and remoteness of damage. And just before we start, just to put it in context, we have noted that before a plaintiff can bring a successful claim in negligence, the plaintiff must establish the following requirements. First, that the defendant owed the plaintiff a duty of care. Secondly, that the duty of care has been breached by the defendant according to how he acted or he failed to act. And thirdly, that the injury or the damage which the plaintiff is complaining about emanated from the breach of the duty of care. So as you will notice in our previous two episodes on tort of negligence, we discussed how to establish the existence of a duty of care. We've also yesterday just discussed how to prove that the defendant breached the duty of care. So tonight, what we are focusing on is proving that the injury or the damage which the plaintiff is complaining about can be linked to the breach of the duty of care. So we are discussing what we call the causation and also remoteness of damages. So let us keep that in mind. So that is what we are going to focus on tonight. So by causation, we mean that the plaintiff must be able to show a causal link between the defendant's acts or omission and the loss or damage suffered. So this is what we call the chain of causation. So you must be able to show that the chain of causation remain unbroken. In other words, that the injury for which you are seeking compensation, for which you are seeking damages, must be demonstrated to have flown or to have emanated from the breach of the duty of care. So let us keep that in mind. So that is very important. Now, in discussing causation, we first talk about what we call the factual position. That is to say that the breach of duty of care by the defendant, that is the tortfeasor, must have been the factual cause of the damage. That is to say that had it not been for the breach of duty of care by the defendant, you wouldn't have, for example, suffered or encounter what you are talking about or what you are blaming on the defendant. So let us keep that in mind. And to do that, we often use the principle we call the but for test. But for test, just from the normal word but and then for. That is to say that but for the breach of duty of care by the defendant, alleged tortfeasor, you will not have suffered the injury or the damage that you suffered. So let us keep that in mind. And a very good case in which factual causation, which is established by the test of but-for test, came out clearly in the case of a Koch against Kirby McLean Limited. In Koch, Koch as in C-O-R-K, Koch against Kirby McLean Limited, decided in 1952, a workman who was an epileptic, that is someone who suffered from epilepsy, was set to work painting the roof inside a factory, which necessitated his doing the work from a platform which was about 23 feet above the floor of the factory. So the platform was around 27 inches wide and was used for the deposit of the workman's bucket and brush. There were no guardrails, something that you can hold on to guide you as you are climbing or descending. So the workman, who was the epileptic, fell from the platform and was killed. So eventually, when those who are entitled to the estate, for example, brought up a claim in court, an issue arose as to whether his death could be blamed on the breach of duty of care. And Lord Danning made important statements, a dictum, which is often cited when we are talking about but-for tests. So anytime we mention the case of Koch against Kirby McLean Limited in trying to support the but-for test, remember what Lord Danning said. Lord Danning said that if the damage would not have happened but for a particular fault, then that fault is the cause of the damage. If it would have happened just the same, fault or no fault, the fault is not the cause of the damage. So let us keep that in mind. That is to say that anytime you want to establish factually if the breach of the duty of care is the cause of the damage or the injury, we must ask the question, could the injury, could the damage have occurred had it not been the breach of the duty of care? If the answer is yes, then what it means is that the breach of duty of care is the factual cause of the damage that you are complaining of. On the other hand, if the damage, the injury that you are complaining of would have occurred anyway, regardless of the breach of the duty of care, then we cannot say that the breach of the duty of care is the factual cause of the damage. For that matter, the factual causation is not made up. So let us keep that in mind. Well, you all remember the well-known case of Barnett, especially those who did, of course, medical law too. The case of Barnett against Chelsea and Kensington Hospital Management Committee, decided in 1969. In Barnett case, a patient was turned away from a casualty department by a doctor who refused to examine him. He later died of arsenic poisoning, and it was shown that the man who have recovered, would not have recovered, the man would have died anyway, even if a doctor had treated him. So those entitled to his estate brought up a case in negligence, and the argument was that the Chelsea and Kensington Hospital Management Committee breached duty of care by not making a doctor at the casualty attend to the patient, but rather sending him away, a patient who had been poisoned, but had been given arsenic poison. Now, during the trial, evidence from pathology and other medical sources prove that even if all the doctors at the Chelsea and Kensington Hospital Management Committee had actually attended to this patient who was suffering from arsenic poisoning, he would not have survived and he would have still died anyway. And for that matter, the court held that the hospital was not liable for the clear breach of duty in failing to treat the patient. So mind you, the court was prepared to agree that the hospital, and for that matter, the doctor owed the patient the duty of care. That is true. And two, the courts also agreed that by failing to treat the patient, the hospital and the doctor breached the duty of care. That is also true. Then we come to the third hurdle. Can we say that the death of this patient was as a result of the failure of the hospital, the failure of the doctor to treat this patient suffering from arsenic poisoning? Now, since there was overwhelming evidence scientifically to demonstrate that insofar as the disease or the condition of arsenic poisoning, the patient was going to die. And for that matter, we cannot establish a link. We cannot establish a factual link or nexus between the death of the patient and the fact that the hospital or the doctor at the hospital failed or refused to attend to the patient. So due to that missing link, due to the absence of link or connection between the death and the breach of the duty of care, the court was of the view that the hospital was not liable for the death of the patient. So, my dear students, let us remember that proof of damage is an essential element of negligence, and it's not enough for you to be happy that you have established existence of a duty of care, and then you've established that there was a breach of that duty of care. More importantly, you should be able to establish that the breach of the duty of care is that which resulted or culminated in the death or in the injury which you are complaining about. Of course, in discussing the Bradford test as the dominant approach many years in trying to prove the factual causation, we may be tempted to think that it is a very straightforward matter. Nevertheless, there are some difficulties which we need to address our mind to in using the Bradford test or in trying to prove what we call the factual causation. Especially so where you have the phenomenon of multiple causes of damage. That is to say that where the damage that you are complaining of, right, the injury that you are complaining of was caused by more than one thing. In that case, how do you show that it was a breach of the duty of care by the defendant which caused the damage? So that is what we are talking about. And again, where we are also dealing with the loss of chance of recovery, right? A loss of chance of recovery or multiple consecutive causes of damage. They can all complicate how to establish the factual causation of the damage or the injury that you are talking about. So first, let us discuss the phenomenon of multiple causes of damage. So here, we are talking about where there is more than one possible cause of the harm or the damage or the injury which the plaintiff is complaining about. In that case, it is the law that the plaintiff does not have to show that the defendant's breach of duty was the only cause of damage or even the main cause of damage. That does not have to be done. And for that matter, if we look at the very old case and well-known case of Bonington against, Bonington Casino Limited against Wardlaw, you notice that the plaintiff contracted pneumoconiosis after working for years in a dusty condition. And according to scientific knowledge, there were two main causes of dust in the foundry, one of which was required by law to be extracted. And it was impossible to prove which of the two causes of dust actually was inhaled by the plaintiff, and for that matter, the pneumoconiosis which the plaintiff contracted. Now, the court held that since the dust which should have been extracted was at least a partial cause of damage, the defendant was liable in negligence. And the plaintiff only needed to show that the defendant's breach of duty materially contributed to the damage. So the takeaway is that where you have multiple causes of damage, then for purposes of satisfying the requirement of causation, you must prove materiality. You must prove materiality. So let's just keep that in mind. And of course, if you have just only two possible causes, it may be pretty straightforward in trying to show that this cause also materially contributed to the injury or the harm that you are complaining about. So that may be a bit straightforward, but of course, not all the time in which that will be straightforward. So, for example, there are some cases that you may have to fall upon the preponderance of probabilities to actually work your way out. Especially so in medical or clinical negligence cases where you have too many possible causes. How do you show that it is this cause which actually materially contributed to the injury? So if you look at the case of Wilshire against Essex Area Health Authority, the plaintiff was born prematurely and needed extra oxygen to survive. A junior doctor at the hospital inserted a catheter into a vein rather than an artery. As a result, the baby received too much oxygen, which caused damage to the retina and consequent or resulting blindness. If you examine the incident, there were 5 possible causes of the blindness which the baby eventually suffered. And it was impossible to say which of the 5 competing and different scenarios actually had occasioned the blindness. In that case, the court held that causation was not established. In other words, the plaintiff had not discharged the burden of showing that it was the breach of duty of care by the defendant which actually caused the blindness. And in the court's view, if you look at the 5 possible causes, none of the potential causes was more likely to have happened than any of the others. That is to say that the 5 in the court view, they all seem to have equal chances of being responsible for the injury or the blindness which the baby suffered. And you could not actually isolate 1 out of the 5 and say that this particular 1 out of the 5 materially or significantly caused the particular harm, in this case, the blindness. For that matter, the court was of the view that the balance of probabilities had not been satisfied, and the plaintiff failed in his action. Therefore, going by the case of Bonington castings we've discussed, and also the case of a Wilshire, we can say that whenever you have more than one cause, the plaintiff must prove that the defendant's breach must have been the substantial cause of the damage, must have been like the dominant, the material cause of the damage, as it were. So if you remember the case of McG against the National Coal Board, decided in 1973, the plaintiff was employed to clean out brick kilns. The working conditions were hot, dirty, and dusty, but the defendants provided no adequate washing facilities. So after some days of working in the brick kilns, the plaintiff was found to be suffering from dermatitis, skin condition. The evidence adduced during the trial showed that the fact that after work, the plaintiff had to exert himself further by cycling home with brick dust adhering to his skin had added materially to the risk that he might develop the disease. For that matter, the court held that although the employer in the McG against National Coal Board was not liable for injury resulting from the plaintiff's exposure to dust in the normal course of his work, it had materially increased his risk of doing so. So look at it, the court is not saying that it was the failure to, for example, to ensure that the employee was not exposed to dust in the normal course, which was to be blamed for the dermatitis that he suffered. No, the court was saying that if you like, failure had materially increased the risk of getting the dermatitis, because the failure to provide washing facilities meant that the plaintiff was caked in dust for longer than required as he cycled home. And for that matter, the employer was to be held liable for materially increasing the risk. So sometimes the breach of the duty of care by the defendant may not necessarily be considered as the direct factual cause. The requirement of causation will be satisfied if it can be demonstrated that it materially increases the risk of getting the particular injury or the particular harm which you are complaining about. So let us keep that in mind. A second, let me pick a call. Yes, Headmaster, can I? Okay, sorry. I have to pick a call. Hello. Yeah, headmaster, you want to go? Another difficulty in proving causation is what we call loss of chance. In other words, if it so happens that the plaintiff cannot establish that, but for the defendant action, but for the defendant breach of duty of care, he will not have suffered loss. Can he rather argue that the defendant's breach has lowered his chance of a more desirable outcome? What do you mean by this? That is to say that if you cannot satisfy the usual basic requirement that, but for the defendant's breach, you wouldn't have had the particular harm or the injury that you are complaining about, you could also satisfy causation in some respects. That is, if you can demonstrate that if the defendant had, for example, not breached the duty of care, you have had a better chance of avoiding the particular harm which you have suffered. And for that matter, you are saying that the defendant's action, the defendant's omission or the breach of duty of care deprive you of the chance, the opportunity to have a more desirable outcome. So if you look at the case of Hudson against East Berkshire Area Health Authority, for example, a boy fractured his hip when he fell from a tree. The hospital made a misdiagnosis, that is a wrong diagnosis, and the boy developed a hip deformity. Now later on, medical experts confirmed that the boy will have had 75% chance of developing the deformity, even if the diagnosis had been made correctly. In other words, assuming there had not been any wrong diagnosis by the hospital, right? There was still a 75% chance of the boy developing a hip deformity. The English Court of Appeal agreed with the trial judge, who awarded the boy 25% of damages, which was considered appropriate for his injury, for his loss of chance of recovery. In other words, the trial judge said that since medical evidence showed that even if there had not been a wrong diagnosis, you will still have developed deformity of the hip by 75% probability. So therefore, if we are going to even allow you to recover compensation, we will try and find out in a situation where the whole thing could be blamed on the misdiagnosis, if it's 100. And now that we know that even if there have not been misdiagnosis, you will still have had 75% chance. We are going to award you damages to reflect only the 25% chance of you avoiding the deformity, which you are deprived of as a result of the misdiagnosis. So that is how the court go about it. But when the matter got to the House of Laws, the House of Laws disagreed with how the Court of Appeal went about it. And the House of Laws went back to the usual or the traditional or conventional approach, or what they call the all or nothing approach, and came to the conclusion that since there was only a 25% chance that the hospital's negligence had caused the boy's injury, this did not satisfy the balance of probabilities. In other words, the House of Laws was of the view that we demonstrate that the harm being complained of was either caused by the breach of duty of care by the defendant on balance or preponderance of probabilities or not. So, and there was nothing like apportionment, like what the Court of Appeal sought to do. That the since medical expert says that even if there has not been misdiagnosis, there's 75% chance. So therefore, we are going to hold the defendant, responsible for the 25% chance he deprived you of having like a desirable outcome as it was. So let us keep that in mind. And but what about where you have multiple consecutive causes? Multiple consecutive causes, no, that is to say that the causes are just all happening one after the other consecutively. As we saw, or we can see in the case of a Performance Cars Limited against Abraham. In Performance Cars Limited against Abraham, and then this is a two decision. The first defendant negligently drove into a Rolls Royce car, and the Rolls Royce was later negligently struck by another car, driven by the second defendant. So if you like, typically when you have what they call like the multiple collision on the road, or if you like the multiple car accidents, in one car ran into another negligently, and then that also ran into another, that way. So that is the kind of scenario we're looking at in the multiple consecutive causes. So the court held that the first defendant, that is the first person to negligently run into the first car, remained liable for negligence. And the second defendant was not liable for the damage which will be occasioned to the vehicle. Since in the court view, the car would still have needed a repairs or respray at the time of the collision with the second defendant, as it were. Then again, we have a third dimension of causation. We'll be saying that there should be proof that the chain of causation was not broken. The chain of causation remained intact throughout, from the moment the breach of duty occurred, right up to when the injury that you are complaining about was suffered. There should be no break in the chain of causation. But it may so happen that the chain of causation will become broken by the phenomenon of Novus Actus intervenens. Novus Actus intervenens, which simply means that a new act intervenes. That is to say that between the breach of duty of care and the injury or the damage or the harm, for which reason the plaintiff has come to court, there might have been an intervening act, a new act, which interposes itself between the breach of duty of care and the injury that the complainant is complaining of, as it were. So where that is the case, if the intervening act is sufficient, is adequate to break the chain of causation, then the defendant who had breached the duty of care will not be liable for the injury because the chain of causation has been broken. And question may arise, in what ways may we have Novus Actus intervenens? When can we say that there is an intervening act which effectively breaks the chain of causation? So this may happen through a third-party act, right? A third party doing something which will actually intervene in this whole cause and effecting, so as to render the original breach of duty of care irrelevant or impotent, as it were, in bringing about the particular harm or injury or damage which the defendant, the plaintiff is complaining about. Or the intervening act may be an act of the plaintiff. The plaintiff himself may do something which may somehow emasculate the effects or the potency of the breach of the duty of care of the defendant, actually causing the injury or the harm that you're complaining about. Or there could be act of nature, or is the act of God may also intervene in order to take over responsibility from the breach of duty of care by the defendant, as it were. Now, for a third-party act to actually be sufficient, intervening acts in breaking the chain of causation, it must be demonstrated that the third-party act is something which could not have been foreseen. In other words, if the intervening act by the third party could have been foreseen or ought to have been foreseen by the original defendant, that is the tortfeasor, then he cannot escape liability for the injury. The third party act can only operate to break the chain where it could not have been foreseen. So let us keep that in mind. So for example, if you look at the case of Baker against Willoughby, as well as the Joblin against Associated Dairies Limited, which is a consolidated case. Like, let's take the Baker, for example. The plaintiff was knocked down by a car due to the negligent driving of the defendant. The plaintiff suffered a permanent stiff leg as a result. After the accident, but before trial took place in the case, the plaintiff was shot in the injured leg during a robbery at work. As a result, his leg was amputated. So you see the events. You are negligently knocked down by a car. You have a problem in your leg becoming stiff. But before the case was tried, you are involved in another incident. You are shot at the in the leg, and your leg is going to be amputated. So the court held that the Gunman's Act was not a Novus Actus Intervenence, and the defendant remained liable. And the plaintiff's loss of earnings was as a result of the original act. That is, he being negligently run into. And the court reasoned that the later robbery leading to him having the bullet in his leg, and for that matter, amputation, did not change this, despite the fact that the damage was different and more severe. Now, the gunshot in his leg as a result of the armed robbery he was later on involved, it certainly made his situation worse. But if you look at it, before that, his earning ability had actually been depreciated as a result of the injury he had through the, if you like, the careless driving, as it were. But in a related case, Joblin against Associated Dairies Limited, decided in 1982, the plaintiff was injured at work due to his employer's negligence. The plaintiff slipped and injured his back and lost 50% of his earning capacity as a result. Now, three years later, the plaintiff developed spondylotic myelopathy, and that what we call like a spinal disease. And this had not been brought about by the accident, but he was still unable to work. The court in the Joblin case held that the disease of the spine, that is the spondylotic myelopathy, was a Novus Actus Intervenens, which did effectively break the chain of causation. So the employer whose negligence had caused the plaintiff to slip and all that was actually left off the hook. So that is how it is. Now let us also look at how the act of the plaintiff, the person complaining of injury against the defendant, that led to tortfeasor, where the act of the plaintiff could also be a Novus Actus Intervenens. Now, where that is actually made up, what it means is that the plaintiff will be held responsible for his own damage, or maybe what we call, if you like, the contributory negligence also, in a sense. So that can also occur. And for example, let's suppose that you've gone for, like there's a case which I'm handling. Somebody went to hospital, and had a normal vaginal delivery. The person was asked to come back, 2 weeks for review. The person didn't go back, despite the fact that she had been seeing a bit of a blood flow. And according to her, 3 to 4 weeks later, the blood flow became so profuse that at one dawn, she had to rush to a nearby hospital. And the doctor on duty did not manage her condition well, and that necessitated immediate referral to Conforno Teaching Hospital. And when she got there, they had to perform evacuation of the uterus, removing her uterus and all that, in order to save her life. Now, later on, this person sues the hospital where she had the normal vaginal delivery. And question which arises now is whether the failure of the patient to report back within 2 weeks for review could, for example, assuming we say that the particular hospital she delivered was, for example, even had breached a duty of care, could you say that her failure to report back within 2 weeks could be treated as her own acts, serving as a Novus Actus intervenens, as a breaking the chain of causation? Well, that is yet to be pronounced upon by a court of law, but that is possibility. So let us keep that in mind. So, for example, if you look at the case of McKew, McKew is spelled M-C-K-E-W, McKew against Holland and Hannon, a 1969 case. Now, as a result of the defendant's negligence, the plaintiff suffered a leg injury, and this left the plaintiff's leg seriously weakened. He later fell when attempting to descend a steep flight of steps with no handrail, and he suffered further serious injuries. He did not seek assistance when he was climbing the stairs. So when the plaintiff came to court, the court held that the plaintiff's act in attempting to descend a steep staircase without a handrail in the normal manner, and without adult assistance, when his leg had previously given way on occasions, was unreasonable. And for that matter, his act was Novus Actus intervenens, which had broken the chain of causation. So the defendants could not be held liable for the injury that they suffered. So you see that there are cases that in which the court have actually held that the plaintiff's own acts can be treated as intervening act to break the chain of causation, as it were. Now, what about act of God? Well, generally speaking, an act of God or act of nature will not break the chain of causation. Now, where the act of God was unforeseeable and separate from the initial negligent act or omission, then it will serve as Novus Actus intervenens, so that the defendant will not be held liable for the injury which he has suffered. On the other hand, if the act of God was foreseeable, would have been foreseen, could have been anticipated, then it will not be treated as a Novus Actus intervenens. So let us keep that in mind. Now let's address, okay, maybe let's cite one case to illustrate the act of God. The case of Car's Logi, that is like a car, and then L-O-G-I-E, Car's Logi Steamship Limited against Royal Norwegian Government, a 1952 decision of the Privy Council. The plaintiff ship was damaged following a collision. After temporary repairs, the ship then set off on a voyage to a port in the United States, where permanent repairs could be carried out. During the trip, that is the voyage across the Atlantic, the ship sustained further heavy weather damage during a storm. So the court held that the defendants who had caused the initial collision negligently were not liable for the damage which had been caused by the storm while the ship was on its way towards the United States. Because in the court view, the storm could have happened on any trip, any voyage, and therefore the damage caused by the storm was not a consequence of the collision. It was unforeseeable. It was quite a separate development. For that matter, it broke the chain of causation in order to exculpate the original tortfeasor from liability. Right, ladies and gentlemen, this will bring us to the last leg of negligence. That is remoteness of damages. Remoteness, of course, not remoteness of damage, remoteness of damage. Let me use a careful word, because the damages refer to the monetary compensation, right? And then the damage refer to the injury. So we are now discussing remoteness of damage. And some test writers may refer to remoteness of damage as the legal causation, what we call causation in law. So far, the general causation that we've discussed is what we call the factual causation. That is to say that factually, can we link the breach of the duty of care to the injury which the plaintiff is complaining about? So that is a factual causation. That is what we'll be discussing. And we said that the usual way is to apply the bad fault test. Now, where the bad fault test and you have multiple causes, then you have to find out what was the material cause or the substantial cause. And we've also seen how sometimes there could be a chain in the break of the factual causation. And the break, as we have seen, could be by Novus, Actus, Intervenence, either a third-party act or act of the plaintiff himself, or even act of nature or act of God. Now, I want to talk about the causation in law, legal causation, also known as remoteness of damage. And here, what we are talking about is that for how much of the plaintiff loss should the defendant be responsible? Maybe let me give you a typical, of course, it's a very rough example, but it will help us. So let's suppose that you have a young, let's say a young lady who was, for example, being carried, in a vehicle which was driven negligently. An accident occurred, and let's suppose that she was just about 2 weeks to have her wedding, okay? To have her wedding, and let's also suppose that she had finished school and applied for a very lucrative job, waiting for the interview decision and appointment and all that. So let's suppose that now she's involved in this accident. She cannot walk, cannot move her body. It's going to even affect her ability to have let's say conjugal activities, be able to sleep with the husband or whatever. Will also not be able to, let's say, get pregnant or even carry a baby. Will not be able to probably go and do that creative work. Let's say so many things. So the question is, all these things which the lady find herself in, should she be allowed to hold the person who negligently drove the car in which she was traveling by responsible for all these losses? Now, that is what remoteness considers. Just like remoteness of damage in contract. You remember the Hadley and Basindel, for example, that when a breach of contract has occurred, should the innocent party be allowed to recover compensation for all losses following the breach of the contract, or we should draw a line somewhere and say that for this type of losses, we cannot blame it on the contract breaker. So in the same vein, when a breach of duty of care has occurred, should the defendant be held responsible for all losses or injuries, or should there be a line somewhere and say that for this type of loss, this type of injury, it is too remote from the breach of duty of care by the defendant? So that is what we are talking about. So therefore, if you look at the case of Re Polemis and Intervenence, a very well-known case, the Re Polemis case, as you remember, the charterers of a ship fill the hold with cargo, including a number of containers of petrol. And these fill the hold with petrol vapor, which ignited when a heavy plank was dropped into the hold by stevedore while the ship was unloading, thereby destroying the ship. Now, when the matter came before the courts, the court held that the defendants were liable for all damage, that is all loss or all injuries, which resulted from the breach of duty, regardless of whether that damage was foreseeable by the defendant. In other words, in Re Polemis, the court was saying that so long as there has been a breach of duty of care, all damage which can be linked to that, the defendant or the tortfeasor is going to be held liable. It did not matter that the damage was not foreseeable, as it were. So you notice that the test of remoteness of damage, as established in the Re Polemis case we just discussed, does not actually place any limits on liability for the direct consequences of a negligent act, whether it is severe or not severe, whether it is foreseeable or not foreseeable. And for that matter, a lot of commentators and scholars have criticized Re Polemis as being a very harsh test in trying to determine remoteness of what? Of damages. And of course, certainly as we've seen, that is really worrying. And if you look at the other important and well-known case, what we call the Wagon Mound, number one. The Wagon Mound, as we know, the full is a Privy Council decision, and the full title of the case is the Overseas Tankship UK Limited against a Moths, Docks and Engineering Company. But the vessel at the center of the case is what we call like the Wagon Mound. And the Wagon Mound number one, decided in 1961 by the Privy Council, which also concerns the remoteness of damage. The defendants in the Wagon Mound number one negligently leaked a quantity of bunkering oil into Sydney Harbor from a tanker. And this oil drifted into plaintiff's wharf, where it mixed with assorted detritus, including cotton wedding. Now, at the time, welding was taking place in the wharf. And you know, welding goes with what? With fire. Those of you been to the welder's place. Now, the plaintiff requested and were actually giving assurances that it was safe for them to continue to do the welding. However, sparks from the welding ignited the oily wedding, which caused fire to spread to two ships within the neighborhood, damaging them. And the wife was also, badly. And when the matter went to court, the trial court applied the principle in Re Polemis. Don't forget that Re Polemis is saying that once a breach of duty of care has occurred, all loss, whether it is too severe, whether it was foreseeable or not, it will be blamed on the defendant, and the defendant will be made to compensate the plaintiff for that. So the trial court in the Wagon Mound number 1 actually followed the Re Polemis decision and made the finding that the defendant were liable for the fire damage. Because in the trial court view, fouling the WAF was a foreseeable consequence of the leakage. Now, when the matter went to an appeal before the Privy Council, which is of the same status as the House of Lords in those days, it disagreed with the decision of the trial court and reversed it. And the Privy Council came to a different conclusion in the Wagon Mound number 1 that the correct test for remoteness of damage is reasonable foreseeability of the kind or type of damage in fact suffered by the plaintiff. So, ladies and gentlemen, the takeaway from the not the Re Polemis, the Wagon Mound number 1, as far as the test of remoteness of damage, I'll call it back. As far as the remoteness of damage is concerned, is whether the damage is reasonably foreseeable of the kind or type of the damage. In other words, the damage that the plaintiff is complaining of, can we say that at the time that the incident occurred, it could have been appreciated or it could have been anticipated that a damage of that kind, a damage of that type would result? If the answer is yes, then according to Wagon Mound number 1, the defendant will be held liable. If the answer is in the negative, then the defendant cannot be held liable for that type of damage since it was not reasonably foreseeable. Of course, you see tension or some contradiction between the test of remoteness of damage as seen in the Re Polemis and also the Wagon Mound number 1. And unfortunately, the Re Polemis is still, considered a decision on the issue because the English Court of Appeal actually endorsed it, and the decision has not necessarily been overruled. And for that matter, and of course, we come to Ghana too. In our own, of course, Ghana, we haven't made significant contribution to the common law. And if I say that, what I mean is that almost all the basic principles, as far as tort of negligence is concerned, what our law is what the common law, as determined by the English court, mainly has been. And we haven't made significant or any changes at all. And for that matter, the position of the matter, as far as position in law, is Re Polemis, as well as the Wagon Mound number 1. Therefore, if you like, the two positions are actually good. And all that you need to do is to state what authority you are relying on, and then you argue your point. Because don't forget that they are all, they are all good law. Re Polemis is a good law. Wagon Mound is a good law. But as I say, what is important is that you have to show your cards when you are using them. If you are going by Re Polemis, let's say in the problem-based question, you have to let it be clear if you're doing the application, or if you're using the Wagon Mound, you have to be clear. So let us keep that in mind. And again, the degree of foreseeability, because Wagon Mound says that the damage should be reasonably foreseeable. So the degree of foreseeability which is required depends on whether or not the plaintiff is a primary or secondary victim. And I hope you remember primary and secondary victim. So where the plaintiff is a primary victim, the defendant must or should have foreseen some physical injury to the plaintiff. Even if no physical injury occurs, so far as the plaintiff was a primary victim, if there was a psychiatric injury, the defendant will still be liable. The defendant will still be liable. So just like when we discussed the psychiatric injury or aspect of the nervous shock yesterday, so all those things we discussed are very important in determining whether the particular damage was foreseeable or not foreseeable. On the other hand, if you are dealing with secondary victims, remember the case of the McLaurin and then O'Brien. If you are dealing with the secondary victims, the psychiatric injury must be foreseeable in a person of reasonable fortitude in the circumstances. So there, it is not automatic that the defendant will be held liable, unless it was foreseeable in a person of a reasonable fortitude, someone who does not have any, extreme, if you like, emotional drifts. We use the average person's, if you like, emotional balance, as it were. Now, another point to remember in talking about causation in law or remoteness of damage is the Earthshare rule. The Earthshare rule. That is to say that if the type of injury is foreseeable, right, according to Wagon Mound, but the severity of the injury is not, the intensity of it is not, maybe due to some pre-existing special condition on the part of the plaintiff, then the defendant remains liable for all the losses. Of course, in criminal law, you remember the call, take your victim as you do what? As you find him. So it's a very much the same idea, which is playing out here in tort law, the Earthshare rule, that so long as the injury, the type of injury the plaintiff has suffered could have been foreseen, was foreseeable, it does not matter that the plaintiff had certain underlying condition or disposition, which made the plaintiff, if you like, more amenable to worsening, to aggravation or escalation. The defendant will still be liable. What is important is that, was the injury or the harm, the type, was it foreseeable? If the answer is yes, the intensity does not matter, or the quantitative seriousness or does not matter, or the quality. Even if the particular condition of the plaintiff is going to make it probably more worse than what could have been foreseen. It will still not release the defendant from liability. So that is the essence of the eggshell score rule. And as I said, if you like, very similar to how take your victim as you find him somehow placed in criminal law. For that matter, if you remember the case of Smith against Leach, Brain, and Co. Limited, and then this is the 2 decision. The plaintiff was splashed by molten metal as a result of his employer's negligence and suffered a burn to his lip. This burn triggered cancer, from which the plaintiff died. The plaintiff lip was pre-malignant at the time of the incident. Now, the court held that some form of harm from the burn was foreseeable, although the particular type of harm in the particular circumstance was not. Nevertheless, despite the fact that the death from cancer was not a foreseeable consequence of the burn, because don't look at it, we know that the lip was a pre-malignant, meaning that it was not cancerous at the time. The employees remain liable in the negligence for the full extent of the damage. So therefore, the Earthshare Rule simply means that the defendant must take their victim as they find them. You take your victim as you find them. And the defendant, even when you are talking about even like the psychiatric injury, we also have to take his victim as they find him, even if the victim suffers greater injury than the person of reasonable fortitude. Well, just before we leave, just one last point about causation in law, where you have impecunious plaintiff. Impecunious plaintiff, that is a really poor plaintiff. How is that impacted by the rules on causation in law? If, for example, the plaintiff, for example, lack means, right? Lack money or resources. And for that matter, the plaintiff experiences maybe a certain kind of loss. The position of the law is that the Earthshare Rule does not apply where the losses were as a result of plaintiff lack of means. So if you look at the case of Lies Bosch Dredger, right, against Edison, a very interesting case by the House of Lords in 1933, Lies Bosch Dredger against Edison. The plaintiff's dredger sank due to the defendant's negligence, and the plaintiff could not afford to replace the lost dredger. So in order to fulfill its contractual obligations, the plaintiff hired a dredger at an exorbitant rate. And the House of Lords held that the plaintiff could not recover the high rental charges, since these were as a result of his own lack of means and not immediate physical consequences of the negligent acts. Yeah, so that reinforces the point that your impecuniosity will not necessarily allow the loss, which have been aggravated by your impecuniosity, to be blamed on the defendant. So let us keep that in mind. Good. So let us remember that if you want to answer a problem-based question in tort of negligence, oftentimes only one aspect of the three main elements of the tort of negligence may, for example, be the key focus of the question. But of course, because of the type of examination that you are doing, like the law school entrance examination, anything is possible. If you say anything is possible, it will not be out of place for your examiner, for example, to formulate a question which may not be focusing only on causation, but may also, for example, focus on breach of duty of care as well as causation, or in some cases, as whether existence of a duty of care should be recognized in a particular reverse situation, in which case we have to remember all that we said about the Caparo and Dickman decision. So having exhausted discussion of the tort of negligence, I will pose for any contribution or clarification before we end. And over the weekend, we'll try and discuss, we have some questions sessions. Okay, so since questions and contributions are not forthcoming, I'll say have a very good night.